Good morning. It's a great day here at Elville Associates, and welcome to our Elville webinar series. My name is Jeff Stauffer, Community Relations Director with the firm, and I'll be your moderator today. I'm pleased to share with you our topic, which is Estate Planning and Elder Law Essentials, presented by Elville Associates Senior Associate Attorney Renee Boyd. And you're in the right place for high-level legal education today. We encourage your general questions, so please note them in the questions section on your screen, and we'll pause periodically throughout the presentation to address them. As always, your questions always add value and help others learn, so don't be shy in posing your questions at any time. Yesterday by email, you received today's presentation slides Renee will be referencing, and these materials are also available in the section marked handouts on your screen to download at this time. And to our advisors and professionals on today's webinar, a warm welcome as well. Thank you for being here. 1.5 continuing education hours are available for most everyone in attendance. And if you'd like to submit an ID number or your accreditation to me so I can submit CE hours for approval, please go ahead and do that for me at this time or by the end of today if I don't have them already. And everyone will also be asked to fill out a post-webinar feedback email right after the presentation. So please take just a couple minutes to fill out this brief survey and offer us your feedback about today's presentation. And we read and value every comment that you have to share with us. And here at Elville Associates, we are always here as a resource for your family and you. If you have old planning documents that need to be reviewed or new planning needs to address, or perhaps another matter, Renee and our team are here to advise and counsel you throughout those processes. So I'd like to offer Renee and the firm a brief yet proper introduction before we get started. We have a lot to cover, and we'll go ahead and dive right in. So Elville Associates, if you're new to our webinars, which you know we have several new attendees, we were founded in 2010 in Columbia by our managing principal and lead attorney, Stephen Elville. We have several practice areas that we focus on here at Elville Associates, including estate planning and elder law. We also focus on special needs planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection. Our mission, as it has been and always will be, is to offer practical solutions to our clients' needs through counseling, client education, and the use of leading edge legal technical knowledge. And we focus on education a lot here at Elville Associates. We do that in several ways. We do that through our planning processes with our clients. We have many different programs to suit all families and individuals, and also through many, many educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program. We are one of only a couple firms in Maryland to have a client care program accredited through the Client Care Academy in Boston. And each day with every client, we focus on the ideals of client education, collaboration, and compassion. A little bit about Renee. Renee's work as an attorney for the here at Elville Associates has been centered in elder law, estate planning, and asset protection, among many other areas. She partners with clients in the firm's busy estate department to address all aspects of planning, including the initial drafting of wills, trusts, advance directives, and powers of attorney, as well as the continued revision and updates of those documents as changes occur in the laws and their lives. During the estate planning process, she educates clients and provides them a comprehensive client experience throughout. Renee's past work as a certified financial planner enables her to offer a unique perspective in working with clients during the estate planning process, as she draws from her experience in helping clients achieve their financial planning goals. Renee was also named to the Maryland Rising Stars list for 2024. So Renee, welcome. Thank you so much for being here, and we're looking forward to your presentation. And I'd like to share just a bit more about yourself. We look forward to hearing from you.
Great. Good morning to everyone, and thank you, Jeff, for the nice introduction. As Jeff mentioned, I am one of the estate planning attorneys at Elville and Associates, and do a lot of work in helping our clients identify what their estate planning goals are and putting plans in place to best help them attain those goals. And it's my pleasure to be able to talk to you all this morning. Before I get started, the legal disclaimer, I do need to say that the information that I'm going to be talking about today is for educational purposes and cannot be construed as legal advice. So what are our goals for this morning? What I'd love to do is to talk to you about the estate planning process, I would like to talk to you about why some estate plans are less successful than others and what you can do to make yours the most successful. We're going to talk about wills versus revocable living trusts, and tied to that discussion will be a discussion about probate and non-probate assets. We're then going to start talking a little bit about elder law and how to protect assets and how that impacts your planning. And then we'll finish up with how do you get started? How do you take the next steps? What's the best way to get from point A to point B? And as Jeff mentioned, as we go through this, I welcome as many questions as you have. I do this presentation in person a number of times, and I love for it to be interactive. It's not quite as easy to be interactive on a webinar, but please submit your questions in writing. Jeff will gather them, and I'm going to stop periodically and ask Jeff what questions we have been receiving. So the estate planning process, and why is it important to plan? Going through this process, the estate planning process, really helps you to identify what your goals are. By identifying your goals and putting the plans in place to attain those goals, it's really helping to provide certainty for your loved ones. And it also helps making the administration of your estate a little more smooth when you do pass away. By making it a smoother administration, it can help to reduce the cost of administration, and it gives you the opportunity to put plans in place to protect assets for your loved ones. It can help minimize taxes, and it can help you achieve some of your special goals, whether those goals be charitable giving goals, providing for a loved one with special needs. All of that can be incorporated into your goals and into your plan. So there are really two major types of estate planning. There's the traditional planning, and then there's also educational estate planning. Traditional planning, very transactional in nature, while educational estate planning is much more goal and process driven. Let's talk a little bit about estate planning. This is typically, planning is limited to one phase. It is all about planning and getting a document executed. There's typically little or no education in traditional estate planning. It's very transactional. It's a document transaction, and documents really are the plan. Once the documents are signed, there's typically little or no maintenance, little or no updating. On average, a client will revisit their estate plan every 19 years, and this can really contribute to failure of the plan. If you're not revisiting the plan more often, we recommend every 5 to 7 years. If you're not really revisiting the plan, you're not checking in to make sure your goals are still being met. Now, there's another type of estate planning, and this is educational estate planning, and this is the type of planning that we engage in at Elville and Associates. Jeff, in his introduction, really teed up the importance of education at Elville and Associates. This continues through our entire relationship with clients, but it really begins in the estate planning process. Our educational approach to estate planning, it really incorporates all three major phases of planning. So the first phase is working with you to hear what your goals are, to design the plan, and to get the documents signed so that the plan can be implemented. This is where a number of other planning stops. But we think the second equally important phase is to maintain and periodically update your plan. Again, our recommendation is approximately every 5 to 7 years. And then also we are here to help you as well in the administration of your plan when you pass away. Again, the emphasis is on education, and it's really your goals that are going to drive the process. So, I'll just repeat, maintaining it, updating it, and continuing education that's provided by Elville and Associates is really what is critical to your overall plan success. So now let's start talking about your estate plan. A number of clients that I work with will ask the question when I meet with them, should I have a will-based plan? Should I use a last will and testament? Or should I use a revocable trust? Really, revocable trusts and wills are alternative tools to use to dispose of your assets. We're going to talk about both of them, but let me start with wills. This is what a will-based estate plan would look like. Of course, in the center is the last will and testament. And the last will and testament is really the document that we use to plan for your death. But we also recommend that whether you have a will-based plan or a revocable trust-based plan, that plan also consists of the power of attorney documents and the advanced medical directive that you see on this slide. And these are the documents that we use to help you plan for incapacitated, to plan for a time when you may no longer have the capacity or the ability to manage your own affairs. So, wills. What is a will? What is a last will and testament? It's a tool that is used to distribute the assets upon your death. And it's really to distribute the probate assets. And I'm going to talk about what probate assets are and what non-probate assets are. But wills really distribute the probate assets that you own at the time of your death. Wills are subject to public oversight. What this means is when your estate is open, when your will is admitted into probate, your will and all related documents become matters of public record. So it is subject to public oversight. As I mentioned, the assets that are distributed through your will are probate assets, and they are subject to the probate process. So what is probate first? Probate is really proving that the will is valid and that it is accepted by the court. When it is accepted by the court, your will is probated. It's accepted into probate. What is the probate process? The probate process is really dictated by the courts, and it is overseen by the administrative arm of the court. Some of you may be familiar with the Register of Wills. The Register of Wills is who controls the reporting that has to be done and the timeline of the estate administration process. It all starts with opening the estate. This is when the will is accepted into probate, when the estate is open, and when the personal representative is named. A lot of people call this personal representative an executor. In Maryland, we happen to call it a personal representative. And then the Register of Wills will let you know what you need to do. There are certain filings that need to be made in certain timelines, and there are certain procedures that need to be followed. One of the first things that happens is your personal representative has to file an inventory, which is really a listing of the assets that you owned at the time of your death, as well as the value of those assets at the time of your death. This has to be filed within 3 months of the estate being open. When the estate's open, it also starts the clock that says any creditors that you may owe at the time of your death. It puts those creditors on notice that they have 6 months from the date of your death to file a claim against the estate. Along the way, you as the personal representative need to file accountings. These are reports that will include any additional income that comes into the estate, for instance, a tax return for the person who passed away. It could be another asset that was located. It could be expenses that were paid out of the estate, funeral expenses, cremation expenses, things like that. And then there needs to be these first administration accounts, which is the detailed accounting of what I was just talking about, the money coming in, the money going out of the estate. Now, and that's due about 9 months after the estate was opened. If it is a non-complex and uncomplicated estate and things are going smoothly, your first administration account filing can also sometimes be your final administration account filing. People ask, what is the average cost of going through probate? It's estimated to be somewhere between 4 to 7% of the probate assets. The higher end of that range would only be met if your personal representative is filing for the maximum allowed for personal representative payments or commissions. They can be compensated, and the maximum attorney fees. If we're not looking at the maximum, it would be at the lower end of that range. Okay. I can't talk about wills without talking about probate and non-probate assets. I mentioned that your will controls distribution of the probate asset. But what's a non-probate asset? What is an asset that is not controlled by your will and does not have to go through the probate process? Really, there are two primary categories of these. One category is jointly owned assets. The other category is those with a beneficiary designation. If you have your assets titled in one of these manners shown on this slide, those assets do not have to go through probate. Joint ownership, if you own an asset jointly with someone, upon your death, the joint owner already owns it. It does not go through probate. Beneficiary designations. There are certain assets, probably the most common ones that you'd be aware of would be insurance products, for instance, life insurance, and retirement accounts, whether that's a 403b, 401k, IRA. When you open these types of accounts, you're often asked, or always asked, to name a primary beneficiary and a contingent beneficiary. Now, what about assets that don't necessarily ask you to name a beneficiary? There are designations you can place on other accounts, such as a checking account. Checking accounts do not typically ask or allow for beneficiaries, but you can put a designation on the account that is called a payable on death designation. What this means is the person that you name here receives the monies in the account are payable to that person upon your death, but while you are alive, that person does not own the account. On other types of assets like a car with a title, you can put a transfer on death designation on there, and that says, upon my death, I want title transferred to the following individual. Okay. So just as a recap of these non-probate assets, again, they're going to pass directly to the joint owner or directly to the beneficiary and do not need to go through the probate process, through the estate administration process. Okay. And Jeff, I think I'm going to stop for just a minute to see if we have any questions about wills or if we have any questions about probate and non-probate assets.
Thanks, Renee. No questions as of yet.
Okay, then I will keep going. And now I'm going to talk about a revocable trust. I mentioned this earlier, but the easiest way to think of a revocable living trust is that it's a substitute for or an alternative to a last will and testament. Okay, it is a trust document that is created, unlike a will, which is subject to your information being public. Revocable trusts remain private documents. There is no sharing of private information. Probably one of the primary benefits, why do a lot of people prefer to use a revocable living trust instead of a will, is that you can avoid the probate process if the trust is properly put into place. So if the trust is properly put into place, you do not need to go through the whole probate process of having the estate opened in probate court and having to follow all of the timelines and the reporting requirements of probate court. How do you make sure that a revocable trust is properly put into place or properly created? And there's really two steps. There's actually creating the document itself, creating the trust, but then the second and most important part is funding the trust. And what does funding the trust mean? It means that you need to align your assets to the trust. An alignment can be assigning an asset to the trust, or it could mean making the trust the beneficiary of an asset. But really, all of your assets need to be properly aligned to the trust so that when you pass away, it is the terms of the trust that are dictating the distribution of your assets. What is a living trust not, or what does it not do? The revocable living trust does not provide creditor or asset protection for your assets that are in the trust. It can provide, however, for asset protection for distributions to your loved ones when you pass away, in the form of the creation of additional trusts for instance, for your children. A lot of people will ask me, well, say it saves me in taxes using a revocable trust. It really does not provide any tax savings. If you are subject to estate taxes, you're going to be subject to those taxes regardless of whether it's a revocable trust or a last will and testament. Trust administration. We mentioned in a revocable trust, the person who was in a last will, the person responsible for overseeing administration of your will is a personal representative. With a revocable trust, the person that you're naming is called a trustee. But when you pass away, the trustee and the personal representative have some similar responsibilities. They need to identify the assets that you owned at the time of your death. They need to value those assets, and they need to distribute them according to your wishes. It's just that with a revocable trust, this process of identifying, valuing, and distributing is done outside of the probate court. The average cost for a revocable trust is about 1% to 2% for the administration. This is, as you can see, it's less than the cost of administering a will, but I will tell you that it is a little more costly to create the trust than it is to create a will. So let's take a look at what a revocable trust-based plan would look like. The revocable trust is in the center, okay? It's really what's going to drive the plan. Now, in the lower left hand and the lower right hand, you'll see the powers of attorney and you'll see the advanced medical directive. These are very similar to the will structure. You still need to plan for incapacity, whether you're using a revocable trust or a will. But there are a couple of documents that are unique to the revocable trust, and you'll see the pour over will. The pour over will is, I like to call this a safety net document. I mentioned that you not only have to create the trust, but you have to align your assets to the trust. If you pass away and you have not aligned all of your assets to the trust, it could mean that an estate still has to be opened in probate court. If that happens, though, what your pour over will tells the judge in probate court is that you have a revocable trust, and it asks the judge to please pour over that asset into your revocable trust and let your revocable trust distribute it. The other documents that are unique to a revocable trust structure are assignments. And assignments are documents that we use to help you align assets to your trust. And the assignments would handle the alignment of things like tangible personal property, which is the contents of your home, as well as intangible personal property, which could be income streams. I'm going to now talk about incapacity planning.
Hey, Renee.
Yes.
Can we pause for a question?
Please. I'm sorry.
All right.
Yes.
No problem. So from our good client, Mr. Smith, he asks, what is an in trust for account, ITF? Don't believe he's heard of this before.
Yeah, these are, I'm sorry, let me go back a couple pages. This was on the page, Mr. Smith, that was talking about non-probate assets. It's just another designation that you can put on an asset that says upon your death, the monies in that account are to be held in trust for the named individual instead of paid directly to the named individual.
Okay, very good. Thank you.
Okay. So with incapacity planning, I'll tell you that we're all living longer. Humans as a whole are living longer. But what comes with that increased longevity is probably an increased likelihood that we will at some point experience some type of incapacity. The incapacity is, the inability to manage your own affairs, whether those affairs are healthcare matters or whether they are financial matters. So incapacity planning is the process of putting a plan in place and putting documents in place for when you can no longer manage things yourself and when you can no longer make your own decisions. In these incapacity planning documents, what you're doing is naming someone to step into your shoes. That person is named or called an agent, and the agent is the person who can take over for you, manage your affairs, make your decisions, and communicate your wishes. The types of incapacity planning documents are financial power of attorney documents, advanced medical directives, and a form called a MOLST. And let's go through these. Before I dive individually, though, I want to just comment on why these documents are so important. And some would even argue that they're more important than your will or your revocable trust. In the absence of having these power of attorney and advanced medical directive documents in place, if something happens to you and you no longer have the capacity to manage your own affairs, and if that responsibility falls on your loved ones, without these documents in place, your loved ones, in order to have the legal authority to take over for you, would have to file for guardianship in the circuit court of the county in which you are living. Filing for guardianship, as I said, is a legal process. Depending on the county that you're in, it can be 4 to 6 months before the guardianship hearing and ruling. And while that is going on, your loved ones may not have the ability to act on your behalf. Putting these documents in place should prevent the need or help you avoid the need for guardianship. So let's start with financial matters. If you are unable to manage your own financial affairs, and Maryland really utilizes a two-tiered approach to this. They have two power of attorney documents. The first one is a statutory financial power of attorney, and the other one is a general durable power of attorney. And by using both of these together, it really gives your agents the flexibility that they need. I've had many clients ask me, why does Maryland have two financial power of attorney documents? The first one, the statutory financial power of attorney document, was created by the Maryland legislature. And what it does is it contains the most commonly used or commonly needed powers that your agent may have to have in order to take care of your financial affairs. If the statutory power of attorney document is enacted, is signed, it is backed by Maryland law, by Maryland statute, that it must be accepted by all financial institutions, hence its name, the statutory financial power of attorney. Now, the durable power of attorney contains additional powers. But before I talk about that in a little more detail, some examples of the statutory financial power of attorney powers that are granted or authority granted to your agent would be things like the ability to access your bank accounts to pay your bills, the ability to manage your digital assets, to file your income taxes if you are not able to do so, to manage any real property, any real estate that you may own. That said, there are a number of additional powers that your agent could need. They may not be as commonly needed or commonly used, but some of the examples that are contained in the durable power of attorney document, the power to create a revocable or an irrevocable trust for you, the power to fund or put assets into your trust, to change beneficiary designation. There are even more enhanced powers in managing your digital assets. They can perform a Medicaid spend down of your assets. And I'm going to talk about this when we get to the elder law discussion. What's in importance to a lot of people is who's going to care for and deal with my pets if I become incapacitated. This is giving your agent the power to gift your assets, to be compensated for their time. If you own your own business, they can manage your business. And if you have any interest in a limited liability corporation, an LLC, or a partnership, your agent can manage those. Now, we recommend, I mentioned there are two documents in the state of Maryland. We recommend that you sign both, that you put both into effect, because while the statutory is backed by Maryland law and covers probably the powers that most clients will need, there are a lot of other powers your agent can be granted, and we'd recommend that you put those powers in place as well. Okay. So now
Renee, can we pause for a question?
Of course you may.
Thank you. Good question. How is naming an agent different than having an executor of your will after death? Or is the POA/agent just while still alive?
That's an excellent question. And it's the latter of that question. It has to do with when these documents are in effect. Your last will and testament, although you sign it, it technically does not go into effect until you have passed away. Your power of attorney documents are in effect while you are still alive, but yet are not you don't have the capacity to manage your own affairs. When you pass away, any authority or power that your agent had in the power of attorney document ceases. Now, with some clients, they may name the same person as personal representative as they named as agent under the power of attorney documents. If that is the case, your personal representative may have very similar powers or authorities as they had in your power of attorney documents, but you don't have to name the same person. So if I name person A as my agent and person B as my personal representative, when I die, person A's power or authority ceases and person B's power or authority starts as my personal representative.
Excellent, thank you.
Any other questions, Jeff?
Not at this time, thank you.
Okay. So let's talk about the other type of decisions or support that could be necessary, and that's in the area of healthcare decisions. And the document that addresses your healthcare matters when you don't have the capacity to act on behalf of yourself any longer is the Advanced Medical Directive. Now, the Advanced Medical Directive that we utilize has 3 sections to it. The first section is all about naming who your agent is. Who are you naming to step into your shoes? The second part of the document, some people know this part as a living will. This living will section is your opportunity to document what is important to you when you are at end of life, and also to document what your preferences are for the level of medical intervention that you either want or don't want when you are at end of life. The third section of the document is your opportunity to say what your post-death wishes are. And this would include things like, do you want to be an organ donor? Do you want to put any limitation on what the use of those organs is? Do you want to donate your body to a medical study program? Have you thought about, do you want to be cremated? Do you want to have a funeral service and burial? Do you want any type of religious service? Do you want a celebration of life? If you want to be cremated, any special wishes for disbursement of your ashes? Do you own a burial plot already? Anything that has to do with your final arrangements, this is your opportunity to put your wishes down so that your loved ones know what your wishes are when you pass away. Okay. And then the last document is called a MOLST. This is a medical order for life-sustaining treatment. A lot of people call this the DNR, the Do Not Resuscitate document. I will tell you that this is a document that is not prepared by your attorney. A MOLST is often given to you by a doctor or by a nurse practitioner, by a member of the medical staff to complete. If you are entering a skilled nursing facility, if you are entering an assisted living facility, a lot of times if you're going into the hospital, particularly for maybe a surgical procedure, you are going to be asked to complete a MOLST, and it's whether or not you want to be resuscitated if something happens. So again, this is not something that you do with your attorney. This is something you do with your doctor, but I just wanted to point this out, that this is another document that you can use to document what your wishes are. Okay, and Jeff, I'm going to take a pause here because I'm about to really go into a different topic here. So before I move on to Medicaid and elder law discussion, I just want to stop and welcome, just if anyone has any questions about either wills or revocable trusts or powers of attorney or advanced medical directives before I move on.
Thanks, Renee. I think we have cleared all questions right now. If any pop up in the next 30 seconds or so, I will be sure to pass them along your way before we dive too deep into the next section.
Okay. So what I'd like to do
Oh,
now.
well, let's stop right there, Renee.
Okay.
We have a question about interest in special needs trusts and how to fund those.
How to, an interest in them? Can you say the question again, Jeff?
Yes, she says, I'm interested in special needs trusts and how to fund is the statement or question.
Okay. So special needs trusts, sometimes called, you'll also hear them referred to as supplemental needs trusts. These are trusts that you put in place when you have someone with a special need with a disability. And the reason that we utilize trusts is that a lot of times the benefits that are paid to an individual with the special need or with the special disability, a lot of times those benefits are a benefit that takes into consideration asset levels and income levels. And so if you want to leave money or put money aside for someone with a disability, it's recommended you do so in the form of a special need or a supplemental needs trust to protect those assets and still let the person with the disability qualify for the governmental benefits. Now, there are two primary types of supplemental needs or special needs trusts. One is called a third-party trust. One is called a first-party trust. And then I'll talk about how you get assets into the trust.
But, and Renee, she's just said that she is more specifically talking about the third-party trust, if that's...
Third-party, okay. So third-party trust is when a third party is contributing money on behalf of the person with the disability. And the third-party trust can be created one of two ways. You could create it in your will or in your revocable trust if you are leaving money upon your death to a person with a disability. You can specify that upon your death, when the money is passed to that person, it must be passed to them in the form of a supplemental or a special needs trust. This is considered a testamentary trust because it's really created and funded upon your death. There's also a standalone supplemental needs trust where you could create the trust on behalf of the person with the disability while you are still alive. And what that enables is for you to put money into the trust now, not only upon your death. It also allows other individuals, maybe grandparents, to also contribute to the trust. Does that answer the question?
Oh, so I think partially she says we have a standalone third-party trust. She's unsure if she should open a bank account along with that. So unsure of exactly how to fund, it sounds like, how to fund that trust itself.
Okay.
So I guess different options of how to actually fund the trust.
Okay. Jeff, would you be able to maybe give me this person's email or contact information, and I can follow up after the webinar and have a detailed discussion about this?
Absolutely. Yeah.
Okay.
Thanks.
Any other questions before we move on to elder law? No. Okay.
Sorry, Renee. What are the ways to handle one's home? Should children be put on the deed? Can a quick deed, I assume meaning quitclaim deed, be completed to be used near end of life.
Okay. So, this is oftentimes one's home is a considerable part of one's assets, and leaving that to the next generation is often something we talk about in estate planning. Now, placing your children on your deed is a possibility, but there are consequences to doing that. One of the major considerations are taxes. So if let's keep things very simple. I bought a house for $100,000 and it's now worth $200,000. And if I put my daughter on the deed with me, she is an owner of the house. And when I die, it's going to be treated as if she paid $100,000 for the house. If the house is now worth $200,000 and she goes to sell it, she will own capital gains on the difference between the $100,000 and the $200,000. Okay. If, however, I leave the house to her upon my death, not making her a current owner while I'm still alive, but I leave it to her upon my death, then she receives something called a step up in basis, which is an increase in the cost basis of the house. So what that means is if I paid $100,000 for it and it's worth $200,000, when she inherits the house at the time of my death, it's treated as if she paid $200,000 for it. And therefore, if she goes to sell it for $200,000, she owes zero in capital gains taxes. So one consideration of adding a child to your deed is that they lose the ability to get that step up in basis. The other consideration is whenever you have a jointly owned asset with another individual, you're really opening that asset up in case the other individual has a judgment against them or some type of lawsuit. Okay. So an alternative to doing that, one, you can just leave it to them outright in your will, or you can leave it to them outright in your trust. But even an alternative to that, you could also utilize a life estate deed. A life estate deed, and we're going to talk about this in context of elder law planning too, but a life estate deed in terms of estate planning enables you to you're creating a deed. You are naming in that deed something called a remainder man. Your child or children could be the remainder man, which says upon your death, the house is deeded to your children. During your lifetime, though, you retain the right to live in the house. And if you do a life estate deed with powers, it means that you also retain the right to do with the house what you want to do. You can sell the house, you can take a mortgage out, you can refinance the house, you can do whatever you want. At the time of death, though, at your time of death, the remainder man is already named, so it does not have to go through probate. And the life estate deed also allows for the step up in basis to the remainder man.
Okay, thank you so much, Renee.
Okay, so let's start talking a little bit about elder law. This is really all about long-term care, right? This is about long-term health care, and it is also about Medicaid considerations. In the context of long-term care, is there a way to preserve assets and still receive the care that you need? Can it be done in a way that allows for flexibility? We're going to talk about how do you divest yourself of assets in a way that still lets you retain control of the assets, and how do you qualify for Medicaid? Medicaid, if you require skilled nursing care, if you require admission into a nursing home, a skilled nursing facility, Medicare does not pay for that. In most cases, private insurance isn't going to pay for that. Now, if you have long-term care insurance, a separate policy, it will pay for some of it. It will maybe help soften the blow, but most likely will not pay for all of the cost of skilled nursing care. So what is the option of receiving assistance with the cost? Medicaid is that option. Medicaid is the insurance that will help to provide for skilled nursing care. But Medicaid, very similarly to what we were talking about when we were talking about special needs or supplemental needs earlier, Medicaid is a means-tested benefit. And what that means is the person who requires the skilled nursing care has very strict restrictions on the amount of income they can receive and the amount of assets that they can own in order to qualify for Medicaid. Okay, and this whole area of preserving assets in the context of receiving long-term care, this is really the heart of elder law. So what we're going to talk about is pre-crisis planning. This is planning for maybe the need for skilled nursing home care in the future, but not an immediate need. We're going to talk about some tools that can be used to help you with eligibility for Medicaid. There's a Medicaid Asset Protection Trust. There's a use of trusts that are established under wills that are called long-term care wills. I'm going to talk about crisis planning, what happens if the need for nursing home or skilled nursing care is immediate. The rule of halves, this is an oversimplification, but there is a way with proper planning and planning in utilizing tools and techniques that are Medicaid approved that can allow you to still qualify for Medicaid coverage and be able to retain or keep about half of your assets. That's the rule of halves. They haven't renamed this. I'll tell you, it's shifting a little bit more toward being able to retain about 40%, but they're still calling it the rule of halves. Life estate deeds, I just mentioned this in the context of leaving property to your children, but now I'm going to talk about life estate deeds in the context of qualifying for Medicaid. So pre-need planning, this is before you're in a crisis situation. So with pre-need planning, what we're talking about here is perhaps there's been a diagnosis of some type of progressive or degenerative disease. And from what you're being told by the medical staff, there's an indication that you may need skilled nursing home care in the future. If it's at least 5 years before you would have to apply for Medicaid, there are ways to protect your assets and still be able to qualify for Medicaid and to become eligible. Now, the 5 years, what's the deal with the 5 years? Medicaid will say from the date you are applying for Medicaid coverage, it will look back to the prior 5 years. And if you have tried to divest yourself of assets during that 5-year period, those assets are not excluded from consideration, meaning those assets that you divested yourself of within the last 5 years will still be considered against your eligibility. If you think that skilled nursing care might be in your future, there is a trust that can be utilized. It's a Medicaid Asset Protection Trust, that if your assets are placed into the trust, and if those assets have been in the trust for 5 years before you need to apply for Medicaid, those assets cannot be held against your eligibility. Now, there are some requirements. The ill person, the person who's placing their assets in the trust, cannot be the trustee of the trust, nor can they be the lifetime beneficiary of the trust. So the person who is ill cannot control the trust, nor can the person be the direct recipient of distributions from the trust. You name another person to act as trustee, you name another person as the lifetime beneficiary. The trustee can make distributions to the lifetime beneficiary. The beneficiary could use the distribution for your care, for your needs, but you can't be the direct recipient of that. Okay. Life estate deeds without powers. We talked a few minutes ago about life estate deeds with powers. This is the arrangement where you create a new deed. The ill person can name a remainder man, somebody to receive the house upon his or her death. The ill person retains the right to live in the home for as long as they can or until they die. But the deed is without powers. So in this situation, in order to start the 5-year clock, and the life estate deed does start the 5-year clock. So if the deed's been in existence for 5 years before you have to apply for Medicaid, the house cannot be held against your eligibility, but it must be without powers. The ill person who is living in the house cannot have any powers, cannot have the power to sell the house, cannot have the power to mortgage the house, cannot have the power to refinance the house. Okay. A third option, again, if you're planning in advance of the need, is with the use of something called a long-term care will. This is most often utilized for people that are still worrying about retaining assets but may not have substantial assets. What you do with this, the ill person places all of the assets in the name of the healthy spouse, and the healthy spouse creates something called a long-term care will. So in case the healthy spouse dies before the ill spouse, it specifies that any assets going to the ill spouse must go to him or her in the form of a special needs or supplemental needs trust. Okay, so now we're going to take a look at, but what happens if you need to go into a skilled nursing facility now? What if you don't have 5 years to try to plan in advance? And what we're talking about here is crisis planning. This could be you've had some type of medical event, you're in the hospital, and the hospital will not release you to go home. The hospital is saying that you can only be released if you go into a skilled nursing facility. Are there any ways to try to preserve some of your assets and still qualify for Medicaid coverage? And the answer is yes. There are Medicaid approved strategies that can be utilized. So the first is in the areas of purchase. You can use some of your money, spend down some of your money by purchasing new appliances, purchasing a new car, making improvements to your home. So that is one way to spend down money and to better your chances of qualifying for Medicaid. Another way is through payments. If you have an outstanding mortgage balance, you can either pay the mortgage off or pay the mortgage down. If you have car payments, the same. You can either pay the car off or pay it down. If there are outstanding debts, credit card debt, a previous medical event debt, if you owe legal fees, you can pay off those debts, you can pay off those fees. You can pay for caregiving services for the ill person. And the services don't have to be rendered necessarily by a licensed caregiver. The other thing that you can do is to prepay funeral or burial or cremation expenses for the ill person. But what do you do if you've made the purchases, if you've made the payments, and you still have too much in assets to qualify for Medicaid? There are two other Medicaid compliant strategies. One is called the Medicaid compliant annuity, and one is called the gift and loan strategy. The Medicaid compliant annuity strategy is only for a married couple. You must be married to utilize this strategy, whereas the gift and loan strategy cannot be used by a married couple. Okay, so let's take these one at a time. I'm just going to give you an example of both. Let's say that after you make the allowed purchases and after you spend down through the approved payments, let's say there is still $300,000 of assets remaining that would prevent you from qualifying for Medicaid. With the Medicaid compliant annuity strategy, the money that is left over, let's say the $300,000 in this scenario, can be used to buy an annuity. An annuity is an insurance product that turns an asset, an amount of money, into an income stream. So you would buy a $300,000 annuity, which would make payments of income to the healthy spouse. And the reason this is allowed is while there are income limitations on the ill spouse can't have too much in income. There are no income limitations for the healthy spouse. So you buy an annuity and you convert the money into an income stream that is paid to the healthy spouse. Now, one concern with this is that you want to make sure the annuity is a fairly short-term annuity. And the reason for that is if the healthy spouse dies before all of the income payments are made to the healthy spouse, with a Medicaid compliant annuity, Medicaid must be listed as the primary death benefit. So you want to make the payments kind of short to reduce the likelihood that the healthy spouse will die before the income payments are completed. So in this scenario, what we might say is we'll buy a $300,000 annuity that will make 3 monthly payments of $100,000 each to the healthy spouse, thereby being able to preserve the $300,000. Okay. Now, there's another strategy for somebody not married, and that is the gift and loan strategy. So let's use that same example where after the purchases and after the payments, there's $300,000 still to be spent down. And let's say mom is about to go into a nursing home and mom has a daughter. And for purposes of this example, let's say that the cost of the nursing home or the skilled nursing facility is $10,000 a month. What the mom can do, gift and loan, what the mom can do is gift about 50%, there's a formula, but it's about 50% of the $300,000 to her daughter, and she can loan about 50%, the other $150,000 to her daughter, and her daughter has to sign or execute a promissory note, an agreement to repay the loan. Now, Medicaid will not penalize the loan because it is not a gift. It has to be repaid. Medicaid will, however, penalize the gift. So let's look at this. When they penalize the gift, the $150,000 gift, how long will they penalize it for? In our example, we're saying that the nursing home is going to cost $10,000 a month. If mom had not gifted $150,000 to the daughter, mom could have paid 15 months of nursing home fees. Therefore, mom is going to be penalized for 15 months. It means she will not be eligible for Medicaid coverage for the 15-month penalty period. But remember, the daughter has signed a promissory note agreeing to repay the mom. And let's say that the promissory note is that she agrees to repay it over a 15-month period. The daughter makes the first month's repayment of $10,000 to the mom, and that money can be used to pay the first month of nursing home costs. And that continues for a period of 15 months. The daughter repays $10,000 a month. The $10,000 a month is used to pay the nursing home fees for that month. At the end of the 15 months, the penalty has been satisfied and Medicaid starts paying. So in the 16-month, Medicaid will cover the costs. And in this case, the daughter has been able to retain or keep $150,000, and that is the rule of halves that we mentioned earlier. So I apologize that this was so complicated in the example. It's a fairly complicated strategy, but it's actually a very effective strategy as well. So I wanted to make sure I wanted to make sure that I walked you through that. So before I turn it over to Jeff to talk about Elville and Associates Client Care Program, Jeff, I want to stop here and see if we have any questions on any of the Medicaid strategies I just discussed.
Renee, not at this time.
Okay.
But that rule of halves explanation was so good that I now, after 10 years at the firm, fully understand what the rule of halves mean.
Well, I'm glad I could help, Jeff.
Very good. Thank you.
So I think I am going to stop talking for a minute, and Jeff's going to talk to you about a program offered at Elville and Associates. And this program is really all about, I think we're coming full circle to when I kicked this off and I said, you know, what are ways to increase the likelihood that your estate plan is going to succeed? And one of that is continuing education, remaining aware of changes in estate planning tools and strategies and laws, and staying educated and revisiting your plan periodically. So Jeff, do you want to talk a little bit about what our client care program is?
Oh, sure, Renee, thank you. So, yeah, our client care program has been around for several years, I think 8 years at this point. And, you know, Steve and the team, I think back in 2015, went up to Boston to learn how to run a successful client care program. And really, it's the best and highest form of partnership between the firm and our clients. And it ensures meeting with our clients once a year to review your planning. It ensures continuing education. It ensures that 19 years between meeting with your attorneys doesn't happen. And you know, we have many different benefits that come with the program, including, again, meeting with your attorney once a year, quarterly education events. We have a nice social event, enrollment in some programs that would benefit you, such as DocuBank and Everplans, and you know, many other events and benefits that come with it, with your membership. I direct the program. If you have any questions or want to learn more, how to enroll and everything that really comes with it, I'm very happy to have a one-on-one discussion with you if you'd like, at any time at your convenience. And it's something we're very proud of here at the firm. We're one of only, like I said, a couple firms that do have a comprehensive program like this. And you know, several of our clients do take advantage of it and are very satisfied with how it's helped really kind of deepen the relationship with the firm and us with them. And so look forward to speaking with you about it. Reach out to me directly with questions. Always happy to talk with you about it.
Thanks, Jeff. Some of you participating in this webinar may already have some estate plans in place, may have some documents in place. Some of you may just be starting to think about estate planning. What I would welcome you to do, what's the first step that you can take? And it's to schedule a consultation with one of the estate planning attorneys at Elville and Associates. For estate planning, the consultation is a no-charge consultation. And what we can do is either talk to you about existing plans that you have in place and how, or if and how they may need to be updated, or it could be just sitting down and talking to you about what your goals are and brainstorming about how to put a plan in place to best meet your goals. I know this is an uncomfortable topic for some people. I will say there's really nothing to fear. There's information to learn, but that's what we're here for. We're here to walk you through this, to help educate you, and to help you put something in place to meet your goals. So I would just welcome anybody who's interested. Just reach out to Elville and Associates. The last page of the presentation that Jeff sent you has our phone number. It has my email address. It has Jeff's email address. We welcome you to give us a call or email, and we would be more than happy to set up an appointment to meet with you and discuss your estate planning needs.
Renee, thank you so much. Wonderful job. And I'll say that after too many years, even though I work at the firm, I went through my estate planning update with Renee recently, and it was a wonderful experience. So Renee, thank you for me personally for all your help.
You're
and
welcome.
Great job today.
Thank you.
So we have one question here, and now would be a great time to get your final questions into Renee as we go ahead and wrap up here in the next couple minutes. And the question is, does the promissory note you alluded to require a family member, or can it be anyone you trust, maybe a life partner?
It's always been explained to me, and I've always seen it put into place with a family member. Again, Jeff, if you can maybe take this person's information, I will find out if there's any legal reason why it has to be a family member, or why or maybe it's just that that's typically what we see.
Sure.
Thank you.
Not a problem. Okay, as we wait for any final questions, as always, and for those that are new to our webinar series, I'll be sending out a follow-up message with our video link from today and the slides once again, and some other resources that Renee alluded to in today's presentation. As our webinar series moves forward, we have on Tuesday our wellness series coming back. Really excited about this next topic, the power of relationships. And we'll have Dr. Michelle Fritsch, who's a friend of our firm in our webinar series, coming back to talk about that. And we'll be at the Brain Injury Association of Maryland conference next week. If you're going to be there, please stop by and see me. I'll be exhibiting, and Steve will be presenting on Friday. And on March 27th, we'll be talking about our quarterly presentation, Trustee Selection, and how to choose the right one for you. Always look forward to that with Steve. And on April 3rd, what families need to know about planning for a loved one with special needs, also with Steve. And we'll go into some more presentations in April, and also have a busy May planned for you as well. So see if we have any further questions here, and then we'll call this one a success, Renee. No other questions, so thank you for your time today. Thanks for being part of the Elville webinar series. Renee, thanks again for being here, and we'll see you again soon. Have a great day, everybody, and a nice weekend ahead.
Bye-bye now.